Governor Gavin Newsom signed a new gun control bill today. It allows victims of gun violence, the Attorney General, and local governments to sue gun makers when they do not follow state law.
Chris, the California Rifle and Pistol Association told me that they already have plans to file a lawsuit within the week to fight back against this new law. But Chris, I spoke to the author of the bill as well, who told me he was fully anticipating it and wrote the bill in a way that he thinks will survive a battle in court. Assemblymember Phil Ting said it's a day he's been working toward for a year now.
Californians will now be able to take the power back into their own hands and sue the firearms industry, gun manufacturers, gun distributors, gun store owners if they're not following California law, if they're not being responsible corporate citizens. So unfortunately, we'll have to wait for the next firearms shooting to occur before someone can hold the industry accountable.
1 year later,
a California judge smacks down lawsuits against the gun manufacturers for misuse of their products. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms for your NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. Any like channel, like content, what I do here, you can support me with a link. Everything is appreciated. And once again, for my Connecticut residents, if you plan on getting your Connecticut pistol permit, please get the training done before July 2024, because then after that it gets longer, harder, and more expensive. If you have your permit, watch that expiration date. There is a link to the online renewal portal for the state of Connecticut for pistol permits in the description box. Keep an eye on that. Let's talk about this. And this is really great news, seeing that we have so many lawsuits floating around against gun manufacturers because some fool used their product specifically to commit a heinous act. Now, a California judge, his name is Andrew Schlapler, is granted an injunction against California's law, which is AB 1594. It is the Firearms Industry Responsibility Act, which allows California residents to sue gun manufacturers if a product of theirs is used in a nefarious manner and causes death or harm. Now, of course, immediately, as I've talked about this a lot, of all the lawsuits that are floating around out there against the gun manufacturers. How are you going to sue a gun manufacturer because somebody uses a lawful product in an illegal way? If the people at Waukesha were to take the SUV manufacturer to court, the judge would laugh it right out of court and it'd be over. But it seems that because it's a gun, it's, absolutely justified for you to go after them. But I want to come into here to give you some information on this good news, but I'm going to blow this up. California slapped for unconstitutional law allowing frivolous lawsuits against gun lobby. The Firearms Industry Trade Association, this is NSSF, applauded the decision by U.S. District Judge Andrew Schlapler, granted an injunction prohibiting the enforcement of California's law that exposes firearm industry members to lawsuits in California for the lawful commerce in firearms that takes place entirely outside the state of California, when those legally made and sold products end up being misused by criminals and others in California. The ruling by Judge Schlapler in the U.S. District Court of the Southern District of California enjoined the enforcement of California AB 1594, the so-called Firearm Industry Responsibility Act. NSSF sued to challenge the law in June of 2023 and moved for an injunction. In granting the injunction, Judge Schlapler found the law is likely unconstitutional because it violates the Commerce Clause. Quote, "We are thankful the court enjoined the state from suing members of the firearm industry under this unconstitutional law that attempts to use the real threat of liability on commerce beyond California's borders and impose its policies, choices on its sister states," stated NSSF Senior Vice President and General Counsel Lauren G. Keene. Among other provisions, California AB 1594 bans the manufacture, sale, and marketing of firearms the state deems abnormally dangerous, which they don't define because abnormally dangerous is what they deem is abnormally dangerous. It allows civil lawsuits against a firearm industry member to be filed by the Attorney General any municipality and any person who claims to have suffered harm from the misuse of a legally, lawfully sold firearm by a remote third party, which means Glock is in Georgia. Somebody uses a Glock in California to hurt somebody, they can then sue them because somebody took that product into California and caused that harm. The law unconstitutionally invades the sovereignty of sister states by directly regulating lawful commerce occurring entirely outside the state of California in violation of the Commerce Clause and the United States system of federalism. The law also violates the Protection of Lawful Commerce in Arms Act, P.A.N, enacted by Congress in 2005 to stop just these sorts of frivolous lawsuits against members of the industry. P.A.N added, "We are reviewing the balance of the court's decision and whether we will file an amended complaint to provide the court more details on how California's unconstitutional law and its threat of crushing liability is causing real and ongoing harm to members of our industry." NSSF claims in its lawsuit that the law also infringes on the Second Amendment and chills First Amendment rights by restricting protected free speech, advertising of constitutionally protected products that are lawfully made and sold, even when that advertising takes place outside of California borders. Let's come out of that. So this is once again a good step, this is something that should be taken up in the United States Congress. A law that states you cannot just sue a gun manufacturer because somebody uses the product to hurt someone else. Now, of course, there's always going to be that divide. If the firearm malfunctions, a legitimate malfunction, and somebody's harmed of it, well, then yes, you should be able to go after the gun manufacturer if it doesn't work properly, if it doesn't work as designed. But to then say, well, because somebody used it, a criminal used it, regardless of how that criminal got that firearm, uses it to hurt someone else, you can't sue the gun manufacturer. That's just asinine. But realize that all of these lawsuits have a very pointed purpose, and that is to bankrupt the gun industry. That's why they're doing it. If you remember, I've done story after story after story where I talked about there's a collection of lawyers, a group or cabal of lawyers across the country who do nothing but go after gun manufacturers, whether within the state they are located or they go to the state where the actual firearm manufacturer is located to then sue them for misuse of their products. This is a pointed, concerted effort for no other reason than to bankrupt the gun industry. And these people who file these lawsuits, well, they're getting paid, so why not? If you remember, and a good example, and this is putting the PLCAA, it brings it into light, that what happened after Sandy Hook, they did not sue claiming that the gun manufacturer was responsible. They sued claiming that the gun manufacturer violated an advertising clause in Connecticut law. That's how they circumvented the PLCAA. And of course, if you remember, the insurance companies that insured Remington settled. There were like four insurance companies, and they settled with them. And then they claimed it to be some victory against the gun industry, when in reality, the person that owns it was told by the people bringing the lawsuit for the Sandy Hook people to stay out of the lawsuit, to not get involved. If you remember that whole fiasco that was going on. But this is, once again, this is a good step in the right direction. And as I said before, this should be on a federal level. You cannot just arbitrarily sue a gun manufacturer because somebody used their legal, lawful, properly designed product in a nefarious manner. Because if you do that, you can sue car manufacturers, you can sue knife manufacturers. It just goes on and on and on. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I will see you on the next one. Peace.